How to sue your ex-boss. Here are 12 ways that you can bring a wrongful termination action if your employer fires you. Employment discrimination. This means that you were terminated because of your race, your sex, disability. There are at least 8 or more bases that you can bring. So the number 1 way is discrimination. Number 2, laying off older workers. Older workers have rights. They have time to consider a severance agreement. They have time to revoke a severance agreement. And they have many other rights. If an employer is too hasty in terminating an older worker because of a layoff, they could be liable. Number 3, if you have an employment contract, you may be able to sue under your employment contract. Many employment contracts specify under what circumstances you can be fired for cause. If your employer violates this or other terms upon your termination, you may have an action. Number 4, the Merit Systems Protection Board, or the MSPB. The MSPB is for federal employees. Federal employees have additional rights to their employment depending on what type of federal employee they are. If you are a federal employee, you have certain rights that entitle you to due process. We at Cran Law Firm specialize in MSPB litigation for federal employees across the nation. Number 5, Whistleblower Retaliation. If you report fraud, waste, or abuse within the federal government, you are entitled to whistleblowers' protection rights. Check with your local state's laws to see if they also similarly have whistleblower protection laws. Number 6, Title VII Retaliation. If you have reported discrimination, you are in a protected status and should not be singled out for retaliation or retaliatory termination. Number 7, retaliation for participating in union-related activities. This is a violation of the National Labor Relations Act. Your rights under the Fair Labor Standards Act, which protects employees and ensures that they get a minimum wage and overtime protections. If you filed a complaint with the Department of Labor and you were fired as a result, then you may have an action. Number 9, retaliation for reporting unsafe working conditions or filing an OSHA complaint. The Occupational Safety and Health Administration protects employees by providing a safe and healthy working environment. This includes reporting workplace violence. So if you file an OSHA complaint and you are terminated as a result, then you may have an action. Number 10, if you are part of a union, you may have collective bargaining rights that give you additional due process and appeal rights should you be fired, and they may even provide for arbitration. Number 11, termination for exercising certain legal rights that a state grants you. For instance, it is illegal to terminate an employee in Georgia for exercising his or her right to vote. And lastly, number 12, FMLA Retaliation. The Family Medical Leave Act. If your employer terminates you because you've exercised these rights, then you may have an action. We hope this video has been of help to you if you've been terminated so that you can see whether your circumstances fit one of these grounds or perhaps you have other grounds. Don't let your ex-boss take away your livelihood without seeing if you can vindicate your rights.